Good afternoon, everyone. My name is Fiona Scolding, Queen's Counsel. I am the chair of this afternoon's seminar called the Looming Public Inquiry on COVID-19, Tips on Preparation for the NHS and Other Public Bodies. As we were briefly discussing between myself and my other speakers, Carine, Patry and David Locke, Queen's Counsel, there are a lot of unknowns. What we are here to do is to try and give you some practical help in what any public inquiry may or may not look like, what the terms of reference may or may not be, and practical steps about things like document management, giving evidence, and how inquiries work on a practical basis. We hope you will find the presentations and discussions informative. The idea is that the three of us will speak for about 10 minutes and then we will basically have a discussion amongst ourselves, and we would encourage all of you to use the chat function at the bottom of the screen to ask us questions. We do not, however, promise to be able to answer them all, or certainly answer them all as fully as we would like to. If we don't manage to get through all the questions, we are just a few things. Microphones are all automatically muted, so you don't need to adjust your settings. Videos are automatically turned off, and please do make sure it's turned off. Otherwise, if everybody's video's on, it tends to make everybody else's internet collapse. Please do answer the chat and ask us any questions. And this webinar will be recorded, so you will be able to see it afterwards, and the recording will be uploaded to the website. Now, I think I'm going to be speaking first, but just to indicate, the two other speakers are Carine, Patry. Now, Carine was one of the junior counsel to the Leveson inquiry into the press. She gained a very high degree of public recognition as a result of her work on the inquiry, but she has an enormous amount of experience as to running a very high profile public inquiry, which took place, relatively speaking, fairly quickly. We are also joined today by David Locke QC, who is currently counsel both to some individuals in the undercover police inquiry, which is about to start. I think it's starting in October, if I remember rightly, which is all about the very many different forms of undercover policing that operated in England over the past 50 or 60 years. And he is also counsel to a large number of those who either died, were seriously injured, or have been relatives of those who contracted HIV or hepatitis C as a result of receiving infected blood from the National Health Service, an inquiry which is still ongoing and which is about to start again, I believe, the week after next. I am Fiona Scolding, Queen's Counsel. As you can see, I've got the same dress on as I have in my picture to try and keep consistency. I am currently counsel to 3 strands of the independent inquiry into child sexual abuse investigation, and we have been trying to carry on during the pandemic, so we have been undertaking remote hearings throughout the course of this year. So, turning first to my slides. Right, I'm going to briefly talk about what public inquiries are and the possible shape of any COVID inquiry. Possible terms of reference and basics, really, for about what a public inquiry looks like. I will then pass over to Carine. What I have done in my slides is I spent a couple of hours yesterday trying to think about what the various topics, the start of what the various topics might be that could be covered by any public inquiry. And that's why I have 39 slides, and everybody else has 3 or 4. About 36 of the 39 slides are for you to read at your leisure and agree or disagree with what may well be the potential terms of reference for any putative inquiry or for any inquiry which takes place. And part of the reason for doing that is so that we can have a springboard to have some discussions during the course of today about what an inquiry might look like and what the terms of reference may well be. So, what is a public inquiry? As you know, there has been pressure building for a public inquiry pretty much since lockdown was announced. However, at PMQs on the 15th of July, the Prime Minister Boris Johnson said, yes, I will be holding an independent inquiry. Subsequent to that date, there have been no further details about what's going to happen, when it's going to take place, and in what form. Sir Edward Davey, who is now the leader, as of last week, I believe, of the Liberal Democrats, wrote officially to the Prime Minister at the end of July, indicating that a public inquiry could and should be set up very rapidly over the summer for and be reported upon by mid-October 2020, and suggested using Martin Ford QC, who had been involved in chairing the Windrush inquiry and had also been involved in various public inquiries. Obviously, we're now on the 10th of September and that has not taken place. Various petitions are currently on the Parliament website and on various other websites seeking a public inquiry, and various groups representing bereaved families have issued pre-action correspondence requesting that a public inquiry is set up and take place. Now, what everybody needs to know is everybody bandies around the term public inquiry, but there are a number of reasons why they are set up, many of which are not compatible with each other. And many of them try to do all of these things and sometimes succeed in doing some of them, but often don't succeed in doing all of them, or emphasise some as opposed to others. So, and this is taken from the speech that Lord Howe gave when he was introducing the Inquiries Act 2005 into Parliament, in that public inquiries can establish the facts where they're not clear. They can learn from events, particularly by distilling lessons to change practice. They can provide an element of catharsis or therapeutic exposure to seek reconciliation, restoration. They can provide reassurance to restore public confidence. They are there to create accountability, to seek to blame, and to provide retribution by holding people and organisations to account. And they are used, ultimately, they are part and parcel of the political process, in that they are there to show that something is being done, or provide the evidence to show that things need to change. So one can see almost automatically that because of the wide-ranging nature of what a public inquiry can be and what it is meant to do, that there may well be a number of different views about what any COVID-19 inquiry should do and what it should seek to emphasise. Should it seek to emphasise the establishment of what happened when, but not seek to learn lessons from events? Should it seek, for example, to provide a degree of catharsis for the families of the over 40,000 people who have died in this country? In what way could it seek reassurance? Should it be a mechanism to avoid civil or criminal litigation? And most importantly, how will the government, as it's already said it's going to perform some form of independent inquiry, seek to set it up, and what mechanism will it choose to do so? So, when we talk about public inquiries, most people think about the full panoply of a public inquiry under the Public Inquiries Act. However, the reality is that a lot of the inquiries we think of as public inquiries, in fact, were non-statutory inquiries. And the Cabinet Office guidance as ultimately a decision whether or not to set a public inquiry up is a matter for a Minister of State, taking advice from the Cabinet Office, which has produced guidance which is published on this question. And the Cabinet Office guidance does not say that inquiries have to be statutory. So they can be either ad hoc or held in either private or public. They can be an inquiry, for example, by a committee of Privy Councillors. The most recent example of which is the Chilcot inquiry into the Iraq War, was in fact an ad hoc inquiry, and they made people up to be Privy Councillors in order so that they could hold the inquiry. Largely one does that in situations where one has intelligence or security information that needs to be heard in private by people who will not leak. Well, Privy Councillors shouldn't leak. I think we all know examples of where they may have done in the past. Another alternative to a statutory inquiry, which used to be very popular but has fallen into almost complete disuse in the 21st century, is the Royal Commission. That tends to be used for what one could call the long-term changes. So, for example, the government could say, why don't we have a Royal Commission on the management of public health during the course of pandemics, at which you would look, at least in part, as to what was happening in response to the COVID pandemic, but it would largely be about policy making and legislative change in the future. Those Royal Commissions fell out of favour largely because, firstly, they took an enormous amount of time, although to be honest with you, they probably, the most recent ones didn't take as long as, for example, the Bloody Sunday inquiry, public inquiry did, and because I think they're viewed as sort of a slightly leisurely way in which to approach matters. There is also obviously the option of a departmental inquiry, which basically is a variation on an internal inquiry, which may or may not be held, may or may not have external experts appointed, may or may not have external members of the judiciary or other experts to chair it, and may or may not have access to various forms of documentation. The potential differences between a statutory inquiry or non-statutory inquiry is fundamentally, if you have a non-statutory inquiry, there's a complete flexibility as to procedure. You don't need to hold all the hearings in public. You can do things by a mixture of public and private. The Chilcot inquiry is an example of that. You don't require to appoint what's known as core participants. You can hear evidence in secret. You can gather evidence in a range of ways. You can use a variety of people to chair the particular inquiry. What you can't do, however, is compel witnesses to attend or compel documents to be handed over. So it can be not terribly useful if you don't have control over the documentation that's going to be provided. So it's very helpful if you've got internal government departments who are going to be the only people who are going to give evidence, for example, to an aspect of a public inquiry, because the government can in effect say, we know we can't make you hand over documents, but you will be handing over documents. But in any sort of COVID inquiry, you couldn't, for example, ask individual hospitals to hand over documents, and necessarily they would be able to say no in those particular circumstances. So those are all the sorts of matters that ministers are going to have to be grappling with, I suspect, as we speak. So the basic requirements of a statutory public inquiry is established by a government minister. It's the minister's responsibility to appoint the chair and panel. You can just have a chair, you can have a chair and a panel. It really depends on what you're going to be looking at, how long it's going to take, what the issues are, as to whether you have a chair and panel. I would anticipate that any inquiry about COVID would have a chair and panel, if not a large number of members of a panel, because the wide-ranging nature of any inquiry means you're going to need quite a lot of people to do the work, all of whom may well have slightly different levels of expertise in different areas. The minister is then responsible with presenting Parliament with the overall terms of reference, which are largely written by the chair and panel, and recently they've been written in collaboration with, or certainly at the very least in consultation with, relevant affected groups. So there is a process before you even get a public inquiry off the ground, whereby you are writing the terms of reference. And that can be quite a lengthy process, depending on the nature of what you're trying to do. Once a statutory inquiry has been established, they are wholly independent of government, and they're staffed. The Secretariat is staffed by civil servants, but they're separate to any department from which they come. And there are various statutory offices which have to be fulfilled, which is firstly the chair of the inquiry, sometimes a judge, sometimes not. Often these days, if they are a judge, they tend to be judges who have recently retired, because there is a view that the judiciary is too busy to spend very many years often on matters instead of its general day-to-day judicial jobs. There is also the counsel to the inquiry, which is a statutory role, solicitor to the inquiry, and the secretary to the inquiry. All of those are statutory posts, so you have to have all those if you're going to have a public inquiry. And any public inquiry report has to be both published and presented to the House of Commons. The other advantages of a public inquiry are, firstly, it can be flexible. You can pretty much adopt any procedures that you see fit. You have statutory powers to take evidence under oath and to compel the production of documents. You can imprison people if they do not provide you with documents and evidence under oath, although I believe that has never happened and has never even, I think, got to the stage of being beyond threatened, but actually steps taken. There is a presumption, however, that the inquiry will be held in public, and there is an express provision that the public should be able to watch. Recent public inquiries have all been broadcast live. The advent of the internet and YouTube means that that has become a lot more feasible than it was 20 years ago. It therefore means that any of you who may appear at a public inquiry have to recognise that it will be on YouTube forever, even if the only people who watch it are you and your mum. The record of proceedings given also has to be made public. And the other advantage of a statutory inquiry is there is a statutory mechanism by which documents can be withheld, witnesses can be anonymised if such would cause significant harm and damage. The downside potentially to a statutory inquiry is a statutory public inquiry cannot make findings of criminal or civil liability. Now, that doesn't mean that you can't use the findings of a public inquiry to found criminal or civil liability, but you are not allowed to express yourself in that way. It cannot be used as a substitute for a criminal trial or as a substitute for civil litigation. The other advantage, certainly to core participants, is the inquiry can make awards of costs and expenses costs and expenses. But those two advantages are also disadvantages, in that the number of core participants in any COVID-19 public inquiry, if it's very broad, is going to be enormous, and the amount of money that you would have to spend on core participants would also be very large. The other problem with any overarching public inquiry is devolution, because you cannot have a public inquiry about the whole of the UK unless the ministers, basically unless the Scottish Government, Stormont and the Welsh Assembly agree that such an inquiry can take place. I think given the political temperature at the moment, the likelihood of all the devolved parliaments agreeing that there should be a UK overall public inquiry, which may well be sensible at least for some aspects, for example, treating patients, BAME and COVID, one can see that is infinitesimally small. The only area where the UK could have a UK public inquiry may well be about the larger economic consequences, as Treasury spending is still, a lot of aspects of Treasury spending are not devolved government cannot be devolved. So there are some issues which could be dealt with UK-wide to do with macroeconomic policy, but even so, for example, the furlough scheme is slightly different in Scotland than it is in England, because of the various different forms of devolution that exist. Healthcare, social care and education are all devolved matters for the administration. So what I think is likely to take place is, if there are public inquiries, there will be 4 separate public inquiries, one for Northern Ireland, one for Wales, one for Scotland and one for England. Some of which may well deal with identical issues, but in slightly different ways. I'm now going to pass over, because what I've done is sort of identify here what I think could be an appropriate model. My personal view, and it is very much a personal view, is having a public inquiry into COVID-19 full stop is just too unwieldy and too large and will take too long. What I think could work would be a sort of hybrid model. So you would have committees of independent experts who could provide rapid evidence reviews, particularly in respect, I would say, of the health aspects of the crisis. So looking at what treatments work, for example, looking at vaccines, looking at public health messaging, could look at that and could report rapidly on what needs to happen next. Certainly if this crisis goes on beyond Christmas this year, then I think you could have a series of inquiries, some of which could be statutory, some of which could be non-statutory, depending on the issues that you were looking at, which look at discrete aspects. What you might be able to do at the end of that is pull together a final report which produces some overall lessons which could be learned, which you might be able to agree should be published UK-wide. So what you could do is you could have the heads of all the different inquiries getting together at the end of the process to produce a sort of UK COVID report. Again, that possibly requires a level of political compromise and horse trading that people might not be in the mood for at the moment. The other alternative would be to have a series of royal commissions about various aspects. But the question is what does the public want or need? Does it want a rapid inquiry about how we can make things better now? Or does it want a more detailed review of what happened in the past? And I think that those two things, you can do both of them in a public inquiry, but looking at what happened in the past takes time. Looking at what needs to happen in the future is something which can't wait. And I'm not sure you can have a public inquiry which both looks at the past and looks at the future, and which can be carried out in the rapid timescales, i.e. in the next 3 to 4 months. I mean, it would usually take 3 to 4 months just to agree on the terms of reference and just to appoint anybody to be the chair and panel, let alone anything else. So I think the idea of having rapid evidence reviews, which would be sort of ad hoc inquiries run largely by panels of experts, is really going to be the only practical way forward for short-term reviews. And then one might want to look at how one could practically run it. Because if one were to have a COVID-19 overall review, I think that would cost, and I'm not joking, hundreds of millions of pounds, on the basis of the fact that I've managed to write 30 slides about different areas which you would want to look at, and that's possibly not the most comprehensive aspect. That's me thinking about it for 2 or 3 hours, not me thinking about it for 6 or 7 weeks, or, you know, a group of people thinking about it for 6 or 7 weeks, which is what you would be looking at. So I'm now going to pass over to Carine, who's going to talk about document management. In terms of which, I'm just going to say, please read at your leisure the millions of slides I did last night when I was getting very excited, particularly the ones about the cultural sector, which is my particular bugbear. But I hand back now to Carine. I think you might need to go back a couple of slides. Thank you.
Thank you. Right. Hello, good afternoon to everyone. Thank you so much for joining us. Yes, I'm going to speak to you about preparation for any potential public inquiry. And before I even start, I mean, the thing about Boris Johnson announcing that there might be an inquiry and the advantage of so many people pressing for some kind of inquiry in the future is that generally you're going to have, if you're a local authority, a public body, Public Health England, it gives you time to prepare. Lots of public inquiries take place very quickly after an event has taken place and gives people very, very little time to prepare. So as Fiona has said, I was involved in the Leveson inquiry, which took place almost immediately after it was discovered that, you'll remember, the murdered schoolgirl Millie Dowler's phone had been hacked by a national newspaper. And on that occasion, an inquiry was set up almost immediately, and it took place shortly thereafter. The advantage of this one, this potential inquiry, is that there is time to prepare, and that's why I'm going to talk to you about practical steps that you might want to take to prepare, either on behalf of a client or indeed it might be you that's having to prepare. Now, I'm going to talk on the basis that this might be a statutory inquiry. I'm going to take you through some of the statutory provisions which might be in play. But of course, the general principles apply, whether it's a statutory inquiry or not. And I'm going to talk to you first about document retention, which sounds like the most boring topic ever, but is really obviously a very important one for lots of different reasons. Now, I'm just going to minimize myself so I can read my slides. Powers, oh, hold on. I need to go backwards. Yep, sorry about that. Right, so the first question is always, why do I need to retain documents? Well, the reason for that is that a public inquiry, is going to sound really obvious, but it's absolutely true. A public inquiry is intended to inquire, which means it has powers of compulsion, if it's a statutory inquiry, to secure access to information. The whole basis of it is that it's meant to be inquisitorial. And mostly, the fact that such powers exist means that disclosure from public bodies or other bodies will be on a voluntary basis, but sometimes disclosure needs to be and will be compelled. And there are lots of reasons why you might need to compel someone to undertake disclosure, including people who are quite willing to disclose, really, but they're worried about the consequences of disclosure, for example. So Section 21 of the Inquiries Act, which is the act which applies to statutory inquiries, contains the power to require disclosure, and the wording is any documents in someone's control or custody that relate to a matter in question at the inquiry. But it's wider than that. There's also a duty to disclose any other thing in his custody. Now, that means, sorry, trying to move between my slides. There we are. Oh no. Powers to require disclosure are very wide indeed. And you can assume, if you're thinking that you might be in this eye of the storm when it comes to a public inquiry on COVID, that everything will eventually come out. So it's important to be aware of what the disclosure obligations are likely to be when you're thinking about how you might prepare. And that means it's really important to retain all relevant information, whether that's by way of emails, documents, or anything else. You'll remember the statutory wording is any other thing. Hard to know what that might be, but certainly anything that might conceivably be relevant to a question the inquiry has to answer. And my advice is keep your documentation organised in a way that will facilitate disclosure in due course. And of course, we don't know when the inquiry is going to be, if there's going to be one. That means being organised now is a good idea. So if it doesn't happen for another 3 years, you'll still be able to disclose in an easy and straightforward fashion. There is, however, I make this clear, people often ask me about this, there's no need to disclose privileged information. So Section 22 of the Inquiries Act says that you don't have to provide any information which you would not have to provide if you would not be required to do so in civil proceedings, which basically means that the civil rules apply on privilege. So maybe have a think in advance. If you're thinking, you might be a public body which might be involved in such an inquiry, have a think in advance about what might be privileged. And you might want to store that separately, or you might want to have a think about whether it is privileged, but it's something which I think is essential to look at. A word or two more about privileged information. Section 22 does mean, obviously, that you don't have to disclose privileged information, but sometimes, of course, information which is contained in a privileged document maybe, you know, discussion with legal advisors and so on, is the only way that actually, when it comes to the inquiry, you can establish that something was actually done or something was actually considered. And it may well be the only way to get your point across to an inquiry. So you might want to be able to disclose at a conversation with a lawyer to show that something was properly considered or legal advice was taken on something. So it might be a good idea to think now about whether you want to ensure that the information is held in a different form, i.e. not privileged, or it's held, so it's held in a way that's privileged, or can be disclosed, or that you can make it clear in a different way. Or in due course, you could waive privilege. And David Locke reminded me earlier today that in the infected blood inquiry, public bodies are in fact waiving privilege. So that's a conversation again that you can be starting to have now. The second thing, practically speaking, which I wanted to speak about today was about capturing experiences, which is a fancy way of saying just making sure that you have got a record of what's going on at the moment. Because although, as Fiona has said, there's real pressure to have an inquiry soon, this is far from sure. So we don't know when it's going to be. And it may be that despite Fiona's very good advice, the decision is taken to have this rather further down the road, and to look back at what's happened rather than to try and learn now from what's happened and to advise for the future. So the best advice, in my view, is to start capturing the experiences of working in the context of a pandemic now. And that should be done at all levels, across the board, from the very senior members of staff right down to the very junior. Now, pausing there, that means having a real putting down in writing what it's like to work in a pandemic. Because it's very easy for an inquiry 3 years down the line to say, oh, why did you do that? And very difficult to get across just how crazy it was actually having to make very difficult decisions in a time of pandemic when there were all sorts of competing considerations. And frankly, getting that kind of experience down now is going to give you your best chance of making sure that you capture just what it was like to be working right now. Bear in mind that inquiry staff, they'll be able to research what's in the public domain. So at Leveson, it was very easy for us to look at what had been said in a report, or what had been said in a particular newspaper article. But of course, it's what's not in the public domain that will need to be understood in due course, the internal workings, you know, what was going on. You know, the newspaper said you were doing X. Why were you doing that? It's the internal story. So make sure your internal story is being set down in writing somewhere. Should you be preparing witness statements or self-reflective accounts now? Well, the thing to bear in mind with this is, it might seem like overkill to be drafting witness statements for an inquiry which doesn't exist at the moment. But Section 21 of the 2005 Act doesn't just require disclosure of documents, it requires preparation of witness statements as the primary source of evidence. And anyone who's ever been involved in an inquiry will tell you that witness statements are absolutely key. And absolutely central. Witness statements allow effectively an inquiry to build upon information contained in contemporaneous documents. So you will not find any inquiry lawyer saying to you, oh yes, I'd love just to have all this documentary disclosure and to work out for myself what's being said. That would never happen. They want you as the responsible bodies or the pressure group or whatever it is concerned to be setting out in writing for the inquiry what it was that happened. And that helps the inquiry staff not just to get a clearer picture of what's going on, it also allows them to have a real idea of what your opinion is on something. It's not just about fact finding, it's about getting an opinion from those who were working for the particular public body or pressure group. And then it will help the inquiry decide who should be called as a witness at any oral hearings, because there often are oral hearings. And there are two ways that an inquiry can get hold of a witness statement. It can either ask you as a public body to prepare them, or it can arrange to meet with witnesses and take the statements. And you can see why that might be the case. So with some very, vulnerable participants to an inquiry, you might well agree as the inquiry that you're going to go off and get a witness statement. But certainly at Leveson, for example, and with most inquiries, we require witnesses to prepare their own statements. And anyway, there's no power to compel someone to come along and simply tell you what was going on. So any preparation now on witness statements is bound to be helpful. I'm not saying draft a witness statement, but certainly be thinking about the fact that you might have to prepare one at some stage. So are you advising me to write a witness statement now? No, because an inquiry may never happen. But certainly, if you know that your organisation or your client is likely to be in the eye of the storm, so you're a large NHS trust, Public Health England, I mean, you know who we're talking about here, then it may make sense to have an internal review now where everyone's experience can be captured, we're back to that phrase, and so everyone can set out what it was like to work in these conditions and can offer lessons learned. And that will be useful for you as a public body anyway, to learn from the process. And bear in mind that much of the evidence isn't just factual, I did X on Y date. It is all about opinion evidence too. And then finally, I want to say a word or two about departure of staff. It's really important to understand, and inquiries, this happens all the time. You know, a participant to an inquiry will say, well, just everybody's left. I can't possibly tell you what was happening then. It is really important to anticipate now, if you can, the fact that staff may leave. So they might move to another job, or more likely, if they've been dealing with crisis management and firefighting, they may just burn out. And that means that all staff at all levels should be keeping documents, memos, minutes, etc. in an organised and easily accessible form. And I mean, my other sort of concrete suggestion would be that any staff leaving should have an exit interview, which all these issues can be identified, just in case, you know, just in case. So even at the very least, they should be able to provide you with a panoply of documents. And if not, I mean, even just have an idea of what their views on something might be. And also it's best to ensure that leavers can be kept in touch with. That's particularly true of senior staff who might have been absolutely crucial in making various decisions, or, you know, collating various forms of evidence, for example. You want to keep in touch with those people, because in due course you may well need them. I think that's everything, and I'm going to hand over now to David, who's going to speak to you about practical guidance on managing the politics.
Well, thank you very much, Carine. Oh, hold on. Can we go back one? I seem to have. Right. Ladies and gentlemen, over the next 10 minutes, I'm going to try and talk about the practical side of managing the internal politics of being in the eye of the storm of an inquiry. For those who don't know me, my background is a mixture of law and politics. I've managed to spread my incompetence far and wide over the past few decades, and picked up a few things on the way. I've therefore sort of tried to distill this into what I think are 5 golden rules. The first golden rule is that when you're thinking about public inquiry, these days you have to assume everything will come out and nothing will remain hidden. And that's learning the lessons from inquiries like Hillsborough, Infected Blood, and other inquiries, where essentially in the past, for good or bad reason, public bodies took a strategic decision about what they thought had happened. And then the evidence was presented, and may have been tailored, may not have been tailored, but it fitted with essentially the official account of what was going to happen. And we saw that particularly in Hillsborough. The problem today, and in fact the problem in the past, is that there is now mountains of digital evidence from which you can reconstruct the timeline. So nothing will be hidden. And there's also the problem of knowing that everybody else knows there's a mountain of digital evidence to construct the timeline. So there's no point in trying to hide something, because there will be 150 paralegals going through all the emails to work out precisely who said what to whom and what the timeline was. And if you try and run an argument which says, well, this is what we really would prefer to have happened, and therefore this is what happened, you will get found out. So the first assumption is everything will come out, nothing will remain hidden. Secondly, what is your job if you are in the eye of the storm in a public inquiry? I think it's relatively straightforward. It's to explain to the public inquiry who did what in your organisation, when and why. So what did people do? Who did the doing? When did they do it? It's really important. And why did they do it in that way? And if you do that, it'll all be fine. And if you don't do it, it'll be obvious. So it's like falling off a log. It's relatively simple, but you get horribly wet if you fall off the wrong way. So next slide. Next golden rule. Thanks. Right. The next golden rule follows on from the previous one, which was your job is to explain in your organization what happened, who did what and why. Don't get sucked into defending or justifying the actions of others. Let others speak for themselves and explain their own decision, and don't try and defend a policy you didn't write, because in the COVID inquiry, there will be a large number of questions about whether the right policies were adopted, and if they were adopted, how did people implement them? If you are in a part of the NHS or social care where your job was to implement the policy, then your job is to explain to the inquiry what it was like and how it felt and what the pressures were on you when you tried to implement the policy. If you are asked, is that the right policy, and you didn't devise it, that's a question for somebody else, because you've got to let those who are responsible for devising the policy explain why it was written as it was at that time, what the competing factors was. You may know some of it, you may not know some of it, you may think the policy is completely barking mad, but you have a duty to implement it. And therefore, I'll just get rid of this mobile phone. Therefore, what your job is to implement the policy. Sorry about that. Sorry, is to explain what you did in implementing the policy, not justify the fact that that was the policy that people chose to implement. I think that's really important. The next golden rule is mitigation will get lost if there's denial. If things have not worked out perfectly, and in my experience, almost always things have not worked out perfectly, then we have to explain on behalf of our clients what went right and what didn't go as well as we wanted, and why things didn't go as well, and why, based on the information we had at the time, not the benefit of perfect 2020 vision, we didn't do something different based on information we didn't have at that time, based on scientific knowledge which wasn't yet around, and based upon a whole series of factors where we couldn't see round the corner. But the important thing is that denial and mitigation are mutually exclusive. If you try and deny something happened, you can never get your mitigation in as to why you did what you did. Alternatively, if you accept that's what happened, you get the opportunity to explain why and to mitigate, and in order to try and explain that it wasn't completely malevolent, you were doing the best you can with the information in a very fast-moving situation. But you can't do both. You can't both deny something has happened and say that if it did happen, you had good reason for doing it. You've got to make your decision. And therefore, as a public body, for those who are in charge of the strategy, you have to work out in advance what you can defend and what you can't defend. And you have to apologize for what you can't defend and mitigate, and you have to defend what you can defend and try and explain. But there's no point in defending the indefensible, because you're back to the first point, it'll all come out. And that brings me to the fifth golden rule, which is that honesty is the only viable policy. Now, this is not just a question of good government or good governance. It's actually the fact that in the modern day, with the forensic detail that we've got of constructing the timeline, any other approach is utterly doomed. Getting found out is inevitable. I think that's my experience with the infected blood inquiry. I suspect that's Fiona's experience. from the sex abuse inquiries. It's certainly what happened in Leveson, that in the end, those people who tried to pretend that something different happened in the forensic process, they got found out. And that leads to the second point, which is quite difficult. You've got to be aware that individuals in your organisation may not hold to your high standard of honesty. So when you are for an organisation saying we're going to be honest, you also have to work out whether the individuals who you are dealing with are also being honest. Now, NHS bodies are this is very common for NHS bodies, because they're used to dealing with inquests where when there's a dispute about what happened, quite often they have to send off a particular doctor or nurse off to get a separate representation, because they wrote up the notes after the event and pretended something happened when it didn't happen. And it's all becomes terribly embarrassing. And the important point for the public body is the public body has a corporate position which may be different to the position of the individuals in the public body who may or may not be telling the truth about what happened in the course of their employment. So it's very important for those who are controlling the public body's position to define honesty as the viable policy, and then work out whether their employees are actually sticking to that mantra or not. Because if in doubt, fess up. It always pays dividends in the end, is my experience, because you always get found out if you don't. Here endeth the lesson. Back to you, Fiona.
I think both Carine and I would echo that a full and comprehensive explanation, warts and all, is what an inquiry is looking for, because it is looking to inquire. It is not looking, and to do that, and to do that properly, requires very heavy levels and high levels of cooperation and high levels of self-reflection, shall I put it that way? So we've had some questions. Now, the first question, and we've also kind of between ourselves discussed various questions. The first thing that I wanted to ask us as a panel is, how do you decide what might be relevant given the wide terms of this inquiry? Do you just keep everything? Or do you sit there and say, okay, well, we might need to keep X's inbox and Y's inbox, because they, for example, were the people in charge of PPE, for example, within the care home, or they were in charge of PPE in the local authority, but we're not going to keep the more junior level because they're not the people who ultimately are making the decisions? Or do you just say, okay, let's keep everything?
I think if I can answer that first. With the advent of cloud computing and the ability of IT systems to retain everything at really quite modest costs, the danger of getting rid of anything probably more than justifies the cost of retaining it, because you're not going to know at this point what is relevant, and it becomes extremely difficult to say at a later date, well, yes, you know, this happened and this happened and this happened, and then we pass it to this person to implement it, but I'm afraid that email, that inbox has been wiped, so we're not really sure quite what happened at that point in the chain.
Yeah, I entirely agree. I think that, I mean, we're only talking at the moment, I mean, you know, it depends how long you're going to be looking, like storing material for, but ultimately we're only looking at the moment of a period of a few months. And the bottom line is that it's going to look awful if you have not kept something which ultimately proves to be something that was actually really required by the inquiry. It will look like you were trying to hide evidence. I mean, at the Leveson inquiry, the police had to rebuild, after the Leveson inquiry, they had to rebuild one newspaper group's, I won't mention the particular newspaper group, but one particular newspaper group had to have their entire back email system rebuilt by forensic experts because they had deleted old emails that would no longer be of any use. And of course, that immediately looked absolutely terrible and like they were deliberately destroying information. I'm not going to comment on whether that was possibly true or not, but certainly it looked terrible. So to the extent that you can keep everything, I say.
But the problem is that there are also sort of competing issues about GDPR, which come into effect, certainly if you're thinking about keeping personal sensitive information. And I think there has to be a balance there potentially, but I don't think that GDPR issues should stop you keeping something unnecessarily. And I mean, the other issue that happened, certainly it happened at ICSA, is a direction was ordered pretty much as soon as the inquiry was set up to say, don't destroy anything. So there was in effect a moratorium, and there still is a moratorium on any public body basically destroying anything to do with potential child sexual abuse. But that, so that would be the other thing, that if there did need to be, I mean, I would say possibly irrespective of how the inquiry ends up, if there is going to be a public inquiry in the near future, there needs to be, that moratorium needs to be issued sort of almost now, saying don't throw anything away from sort of December last year onwards, which is when the first cases were happening. And probably even much further back than that, because one of the issues is going to be about pandemic preparedness and readiness. And that's going to potentially look at issues which go back probably the past 10 years, I would imagine.
Fahita Salim has made a very good point in the chat, which is that there can be some corporate policies for email accounts to be deleted for leavers, which comes back to the point that Carine was making, that you have to keep a track on leavers. And, you know, especially if you've got leavers who are senior people, it would be absolutely hopeless if you said, well, I'm terribly sorry, I don't know what our chief executive would say about this because he retired 6 months after all these events. We deleted all his email accounts, and he's we're not sure where he is now. In which case, hopeless.
I mean, the other point I would make, however, is it's not just a case of having all the emails, which is largely the way that people communicate with each other these days. It's also about finding them in the relevant system, because most organisations have file management systems. In reality, however, lots of people don't use those file management systems. So certainly my experience, and this isn't just at ICSA, but this is just generally, is everybody says, well, we know that they're somewhere, but it can often take a vast amount of time and money to go through and find the particular document, because of the fact that, in fact, it used to be easier when everything was stored on paper because you would have a file and that file would pretty much contain everything. Now, there might be boxes of files in 4 or 5 different places, but now you've potentially got thousands of people's email inboxes which you have to reconstruct all at once. So it is worthwhile, and this is really boring, but looking at, for those institutions that are likely to be in the eye of any storm, looking at trying to get some kind of coherent file management on things to do with COVID so that it's all in one place, because otherwise you are likely as an organisation, if and when an independent inquiry is set up, to spend anywhere between 6 months and a year trying to track down people's emails.
Absolutely. That's what I said in my talk, if you remember, that it is really important to have all this essentially in an easily disclosable form, so that you're not casting around for months trying to figure out what you should disclose. And also to have a look at issues of privilege quite carefully now, it seems to me. So that, again, you're not having to take legal advice, which takes weeks and weeks, on what you should disclose and what you shouldn't. So definitely be organised now. It sounds boring, but it will save such heartache in due course.
And the other thing that people often worry about is the relationship between the inquiry team and yourself, and how far, sort of what strategic approach you should take to dealing with the central inquiry team. Do you two have any words of wisdom on that?
Carine, do you want to go first?
No, Fiona, do you mean in terms of core participants to inquiry and how they can best liaise with the
Yes.
with the
I mean,
team?
not just because what maybe we haven't explained is anyone who is a core participant, so anyone who has a significant interest. It's in my slides, but I sort of elided over it, assuming that most people knew. Anybody who has a significant interest or may be the subject of criticism, which in the context of the COVID inquiry is, as I've already identified, a very large number of people have a significant interest or could be the subject of criticism, then there is, they may well have the right to be core participants to any statutory inquiry. Obviously an ad hoc inquiry operates in a different way and can set its own rules. But also if you're a witness, because I mean, lots of people would not necessarily be core participants, but may well be asked to come and give evidence. How do you approach or what should your relationship be like with the inquiry team?
Well, yeah, I was going to say, just I can certainly tell you lots of things you shouldn't do from my experience. Yeah. Maybe that would be helpful. I mean, at the Leveson inquiry, we had, I mean, obviously I was part of the inquiry team, so I was not someone who was trying to maintain a relationship with the inquiry team, but we had all manner of approaches. So the most sensible approach, obviously, is to be strategically to just take your lead from the inquiry team as to what they need, okay? And you know, obviously people are always trying to get a back channel into what the inquiry team might be thinking, but ultimately it's about taking your lead from them and asking them what they would find most helpful, what approach. But we had everything from invites to glittering parties, right through to, Robert J was the lead counsel to the inquiry, and he was regularly sent ties because he always had a particularly fetching tie. So we had some participants who would send him very expensive ties to try and get some kind of, you know, get his ear on certain subjects. I wouldn't advise any of those things. Don't send flowers to any members of the team. It's really about being sensible, because the inquiry team will have a fairly good idea of what they want to achieve and how you can help them achieve it, and they won't take kindly to anyone trying to be strategic in the way that they approach things. That's my experience. I mean, others may have a different experience.
My experience is acting for public bodies and groups of individuals in inquiries mainly, and the challenge of acting for a public body in the inquiry is that the inquiry team are sort of critical friends and judges at the same time, because the inquiry team want to know what you've got, want to know who said what. That they may well ask you as a public body to prepare your own witness statements in respect of your own witnesses. But then when they don't deal with the critical issues, or if they gloss over the critical issues, then the inquiry team will come back and say that they want more information about X or more information about Y, or they want to know why this document wasn't put to this witness. So attempting to do half a job to protect the public body against criticism by pulling the wool over the inquiry's eyes is generally counterproductive. And that's why I say ultimately you've got to fess up. Equally, a full witness statement which says this is what happened, this is what happened, this is why we took the decision, with the benefit of hindsight, may not have been the right decision, but this was the best decision we took on the time, and at the time of the reasons for them, is about as good as the inquiry could possibly ask for, and gets your opportunity to put your mitigation in right at the outset. So it's about sort of expectation management on the side of the inquiry, you have to cooperate with them, you have to look after them, you have to give them what they want, but you also have to try and retain as much control as you can, legitimate, with the full cooperation with inquiry. It's quite a difficult balancing act.
Obviously, I'm in the middle of a being counsel to inquiry, so I'm quite careful about what I say. But if I could just say that cooperation is incredibly helpful and is always welcomed. I certainly think that establishing a good relationship with the inquiry team through a degree of cooperation and honesty is absolutely essential in any public inquiry.
Can I just say, I've said an awful lot about honesty, and you may get the impression that I think that under pressure, public servants are dishonest. I don't. But where they're honest, it just works so much better for them, where they're open and honest and transparent. There are shades of cooperation. There are shades of reinventing what happened in order to make ourselves not look too bad. And it's not black and white. It's all shades of grey. And I just think we have to be incredibly careful to make sure that when you're being open, when you're being honest, when you're cooperating with the inquiry, we don't end up in a sort of confirmation bias approach where we look at everything through the perspective of, well, we were doing our best, how could they possibly criticize us? The answer is you may well be doing your best, and yet in the circumstances, unless the inquiry understands the pressure you are under, they may look and ask, well, I remember in particular, a long time ago, the Arms to Iraq inquiry, which criticised a minister, and there was an incredibly effective piece of evidence given by the minister, who explained to the judge that he did this ministerial box between midnight and 2 o'clock in the morning. It had 42 items in it, and therefore the one item that this complete public inquiry was about took on average 3.5 minutes. And therefore, you know, yes, he may well have not quite understood all the implications at the time, but in fact, if he didn't every night get no sleep, he had to work on the basis of doing this in 3.5 minutes. And that was putting the context of a decision that subsequently was criticised, but was criticised in the context of, well, we understand the pressure you were under. And that's going to be in spades in the COVID inquiry, where people have been asked to make incredibly difficult decisions with limited information at speed, and they weren't necessarily have made the right decision. I was heavily involved in setting up the Nightingale Hospital in London when that was all made on the basis of perfectly good estimates, a precautionary principle, but things didn't work out as they expected. Doesn't mean those decisions were necessarily wrong, because if they had worked out as expected, those facilities would have been absolutely essential to saving lives.
Yeah. I wanted to sort of think next about how any public inquiry might interrelate with litigation. I know there are concerns in care homes at the moment about the fact that they may well be sued for failure to have adequate PPE, and there may well be civil litigation by the families of the bereaved about the limits on that. How far do you think civil litigation interrelates with and is going to be important when looking at the public inquiry? I mean, I suppose as an absolute outlier, there is the possibility in cases of gross negligence of there being criminal liability or breaches under the Health and Safety at Work Act. If you're looking at employers' failure to have, largely I would imagine this would be around protective equipment and keeping employees safe. But what is the interrelationship between an inquiry and litigation in this respect?
Do you want me to go first?
Yes. Or Carine, maybe Carine first.
Yeah,
Okay.
Carine first.
Well, I was just going to say, I mean, from my experience of doing Levison, we were told from the outset that there was a police investigation, so very different circumstances, because of course the criminal allegations had been made, very serious ones had been made prior to the inquiry taking place. We were specifically told that we could not ask anything which might conceivably touch on a police inquiry. Mm-hmm. So that was completely excluded. But of course, much of what was said at Levison was then used in subsequent civil litigation, which has all been to do with obviously phone hacking and other breaches of privacy breaches and data breaches. And what was interesting about that is that although some may say that Levison failed in the sense that the government didn't wholeheartedly accept Levison's recommendations, what it certainly did do was provide a springboard for the civil litigation, which started immediately thereafter and which is still ongoing. So regularly the cases pop up in the news that newspapers are still being pursued through the civil courts for phone hacking. And certainly the testimony of individuals given at Levison is regularly used to support civil litigation. So that's my experience. We certainly never had any crossover at the time. I'm also thinking of Grenfell. I mean, there's no doubt that the Grenfell inquiries will inform subsequent litigation, undoubtedly.
Well, I mean, what's happened in Grenfell is they've had to, the sort of participants who may well be subject to criminal liability because the police are investigating in parallel. There was a debate which was held just before the start of part 2, which is the portion which is dealing with the people who constructed the building, the people who repaired the building and renovated it, who would be subject to any criminal penalties. The Attorney General can give basically an undertaking which says we won't use anything which is held in the inquiry, but the chair has to apply for that undertaking to the Attorney General. And so that's what has been happening in Grenfell, and that's one of the reasons why part 2 was slightly delayed, because they needed to get, the organisations basically said, we will take the stand, but we're not going to say anything unless we get these assurances. And assurances undertakings were also given by the Attorney General, I think, in the Al-Swady inquiry as well, which was to do with Iraqi detainees and the mistreatment of Iraqis in detention from the British Army, before various army personnel were willing to come and give evidence because of the potential criminal liability. I mean, it's a reason why you tend to sometimes put off some aspects of public inquiries if you think there's going to be particularly criminal proceedings. It's a bit less live in civil proceedings, because obviously people otherwise can say there's a duty against self-incrimination, I'm not going to say anything. And therefore that kind of goes sort of completely against. Now, it's likely in the COVID inquiry that I suspect, you know, I'm maybe speculating wildly about even the likelihood of there being a criminal investigation launched into anything which happens. However, I do think it's something that public bodies will be worried about, and individuals may be worried about if they think that their testimony is likely to lead to criminal action in the future. And so therefore, I think any public inquiry needs to be really clear as to whether or not they're going to be seeking such undertakings from the Attorney General, and if so, in what terms. David?
Yeah, that's precisely the point I was going to make. In practical terms, there's virtually nothing that participants can do to prevent information that they disclose to a public inquiry being used in civil proceedings. And that's probably right, because the information is only, after all, the information which would be disclosed within civil proceedings in any event. Having said that, there may be some issues about waiver of privilege if a public body is asked to waive privilege, and they are likely to be asked to waive privilege on the basis of the infected blood inquiry experience, whether that, an assurance of that no one can use it in civil proceedings. And certainly as far as criminal proceedings are concerned, I would imagine that doctors in particular, in the light of the Baba Garba case, will be very, very cautious about opening up completely about what happened on the ward, for fear that the wrath of God will come down upon them and they'll get hauled off to the criminal courts, as if they were the only person who was involved in providing care and everybody else was entirely blameless, which I think was the problem one of the problems in the Baba Garba case, which I was not instructed, but which I know an awful lot about for various other reasons. So it's an issue that's going to have to be grappled right at the outset of the inquiry, and I suspect in order to secure proper transparency, a Grenfell type undertaking will in the end have to be given, in order that people aren't there terrified by the prospect of having what they say, in all honesty, in all transparency to the inquiry, being misinterpreted and hauled off to the police as evidence of gross negligence manslaughter.
Yeah. I mean, obviously the other area where it's much more likely that there might be investigation about adequacy of equipment, for example, I'm thinking about PPE, as that's the obvious area where I can see civil litigation happening, is inquests. But my understanding is the Chief Coroner's issued some guidance about that, where although they've said that there can be an inquest if there's been some sort of failing, if somebody's died of COVID, they've also said that an inquest isn't an appropriate forum for kind of high-level policy discussions about resourcing and procurement and things like that. And therefore, there may well be a situation, I don't know whether it's happened already because I don't do enough coronial work to know whether or not there's been a stream of inquests which have been suspended, as the Chief Coroner can suspend inquests pending the outcome of any further inquiries. So whilst I could see that an inquest could look at a particular care home's failure, I don't know if somebody were to die of COVID now, to sit there and say, well, why 6 months after we know that this is an issue, do you still not have adequate PPE, or do you still not have people in place, and has there been a failure then? I think whilst that I can see is something which an inquest would look at, an inquest isn't going to look at why is it that the Turkish PPE didn't turn up or wasn't adequate, or because that's much more of a systems issue, which I think the Chief Coroner has said an inquest isn't appropriate. And often in those sorts of system issues, think about Hillsborough is the most obvious recent example. That's why things get turned. The Manchester Arena inquiry, which has just opened, that's part of the reason why that became a public inquiry. So you could have those kind of wider issues, public policy issues, examined at the same time as examining why somebody died. So I think, yeah. We don't seem to have any further questions, but thank you all very much for listening so patiently. There will be a recording and the slides will both be available on the Landmark website, and the recording of this is available on the Landmark YouTube channel, something which I'm sure you'll all be rushing to watch time and time again. Thank you all very much for listening to us, and have a good evening. Thank you. Bye-bye.
Goodbye.
Bye.